So there's different ways to avoid probate, and this fits in with asset protection too. You can, like I said, if the account's not jointly owned, right? So deduction is if it's jointly owned, it probably goes to whoever's on the account with you. The issue with having a lot of names on your account is, and I've had somebody where they had 6 kids, and they wanted to do 2 things. One is they wanted somebody to be able to write checks if they ever got sick. Well, that's what a power of attorney can do, so they don't actually have to be on the account, but that was the reasoning. And the second one was to avoid probate. Okay, so next time I saw them, had eight names on the checking account and the savings account and the brokerage accounts, because we wanted to treat everybody equally too, okay? Problem was, if they get in a car accident, any of those names that's on the account, so now it's not just in my name or me and my spouse, it's 8 of us. Any of them get in a car accident because their name's on my asset with me, the lawyer's going to go and try to sue and get that money, okay? And there's other issues like that you wouldn't think about, maybe, the adult child that's on the account is applying for, or they have a child that's applying for student aid, and so all of a sudden now it looks like they got more money than they do and things like that. So I'm not a big fan of putting multiple names on there other than maybe a small operating account. Like you only keep $3,000 in here. Well, if something happens, it's not a big deal, but your big assets, you definitely want to think that through. Another way to do it is, and probably my preference to having a lot of assets jointly owned, is to have it still be in your name and then have payable on death or transfer on death beneficiaries on the account and have a power of attorney at the same time. So in other words, I could name my 4 kids as beneficiaries or payable on death designation, but until I pass away, that asset's not theirs. So if they get sued or anything like that, that's, my assets aren't subject to that. And then you have the power of attorney in place so that if you got sick and you needed somebody to handle your business, they could do it. Power of attorney is, the ability to basically step into your shoes. And so, without putting them as owners, they can do that for you. The issue that sometimes people forget, though, is if power of attorney authority stops when you pass away. You can't step in a dead man's shoes. Sometimes I'll explain it to clients, or you shouldn't at least. And so basically that's where, we'll sometimes get a call from someone at the bank that says, I've always been writing checks on this account for mom, and I told them mom's gone, and now they won't let me write a check. Well, it might be that they just had power of attorney, and they'll even put names on the account in a POA or power of attorney capacity, so you really want to check that. Like, how do they own it? Are they a joint owner with rights of survivorship, or do they strictly on here as like a signer on the account?